Welcome to another episode of Trial Site News. Our topic for today is going to be the Fifth Circuit Court of Appeals, which recently shot down the tech platform Censorship, which means a Supreme Court showdown is likely. We're going to discuss what happened here. And so, from Trial Site News, I am Adrian, and our episode is starting right now. So, last week, the Fifth Circuit Court of Appeals handed down a major 90-page decision in favor of the new Texas law that opposes the ongoing censorship of social media users by platforms such as Facebook, Twitter, and YouTube. This represents a big victory for the First Amendment freedom of speech advocates, especially here in the age of COVID-19. We are living in a time where the federal government, in an unprecedented manner at least here in the US, freely admits to coordinating and possibly conspiring with big media and big tech to consistently and systematically scrub digital information the government deems inaccurate or worse, misinformation online. Disagree with the government narrative? Misinformation. Silence to those dissenters. And right on cue, the useful idiots, the social media platforms, are the ones that carry out the government's bidding. A First Amendment violation by proxy, or an outsourcing of the business of government censorship. Gotta love those loopholes. Now, of course, the fight for this bill isn't over, and undoubtedly is headed to the US Supreme Court via an appeal, which will make a forthcoming battle of the century that will pit centralizing forces seeking an ever more homogeneously censored reality online versus a hodgepodge of various societal influencers seeking the right to express their opinions, debate, and even dissents online. Now, if the Supreme Court aligns with the Fifth Circuit Court of Appeals, companies like Facebook might not have the leverage ever again to monitor and censor user speech, pandemic emergency or not. Now, given that these federal courts are only one level below the highest court, the Supreme Court, and that another conflicting decision came out from another appellate court recently, this suggests an imminent showdown at the High Court, and the stakes are big here. The Fifth Circuit Court of Appeals decision aligned with the Texas law and points out that the plaintiffs, representing the tech platforms, make what is really a contrarian argument, declaring that the First Amendment serves to not only protect an individual's free speech, but also a, quote, corporation's unenumerated right to muzzle said speech. Now, Fifth Circuit Judge Stephen Oldham wrote in the decision that, quote, House Bill 20 generally prohibits large social media platforms from censoring speech based on viewpoint of its speaker. The platforms urge us to hold that the status is facially unconstitutional and hence cannot be applied to anyone at any time and under any circumstances. We reject the platform's effort to refrain their censorship of speech. It is undisputed that the platforms want to eliminate speech, not promote or protect it. And no amount of doctrinal gymnastics can turn the First Amendment's protections for free speech into protections for free censoring. We explain the relevant doctrine and Supreme Court precedent. Then we hold that this precedent forecloses the platform's argument that Section 7 is unconstitutional. Now, core to the platform's argument, which was rejected by this federal court, however, backed in the past by other cases, is that they should have inherent ability to manage communications on their platform that they deem inappropriate. After all, these are private platforms, right? Such censorship, the platforms would argue, was protected and represented a rare occurrence till the onset of the pandemic. Then platforms such as Twitter, YouTube, and Facebook moved into some sort of pandemic emergency response, seemingly orchestrated with the federal government. In fact, we here at Trial Site News were censored ourselves by these very same tech giants for covering factual data. An example of this would be Facebook censoring us here at Trial Site News when we reported on their social media platform a story involving the nation of Slovakia and their move to temporarily authorize an emergency basis ivermectin use targeting COVID-19. This was back in 2021. We were practically the only source anywhere online to cover that news. But that wasn't to be allowed by Facebook. Reporting factual news was deemed harmful and apparently misinformation, and Facebook went on to scrub the entry clean from their site. When we protested that the article was based on fact, including a formal government edict, it didn't seem to matter. Facebook just ignored the plea and the associated plain evidence that what we here at Trial Site News presented was indeed fact and not misinformation. In any case, regarding this decision last week, a showdown at the U.S. Supreme Court is likely the next step. Acknowledging the importance of this case, Judge Oldham's analysis went deep into the law, even citing some old Anglo-Saxon and Anglo-American legal precedents up through today, backing the importance of the U.S. Constitution and its First Amendment. And if you'd like to see the decision yourself, we will link to it in the description below. And that, my friends, will bring our episode to a close once more. As always, thank you so much for joining me on the program today. For Trial Site News, I am Adrian, and I will see you all